All right, good morning and welcome to the 294th District Court. My name is Chris Martin. I'm going to call this morning's criminal docket. When you hear your name, please say present or here. Terry Johnson. Terry Lorenzo Johnson. No, just say present or here. Thank you, Mr. Johnson. I'll call your case up here in a little bit. Right now, we're just doing roll call. Jimmy Walter Lynch. Here. Thank you, sir. Victoria Nix. Present. Leon Baker. Leon Thomas Baker. John McLeod. John Houston McLeod Jr. Mr. Abraham, we heard those are both Mr. Adams' client. Have we heard anything about Mr. Adams or his constantly? Miguel Angel Castro Govea. Thank you, Mr. Abraham. Bart Jones. Here. Lisa Peace. Here. Joshua Chenault. Joshua Lee Chenault. You see Mr. Chenault?
Judge, I have not seen this morning. We are set for a plea, so I will reach out after we call the docket.
Sean Ray Davis.
Here.
Dakota Dole. Here. Bobby Evans. You say how late? She said about 30 minutes. For the record, cause number CR 23-181, State versus Francis Patrick Gilson, set for arraignment. We confirm that Mr. Gilson is in the Hunt County Jail, so we'll recall that case shortly. Charles Hare. Ryan Higgins. Present. John Johnston. Present. Kristen Lopez. Jeremy Lowe. Here. Ginger Malkich. Here. Alfonso Perez. Alfonso Jr. or Alfonso Perez Jr. Bobby Shaw. Here. Tanya Swart. Here. Tyler Tadlock. Here. Jeremy Snelson. Here. Mr. Snelson, your attorney, Mr. Sanders, is in Longview and he's attending to a court hearing there. He'll be here probably 10 to 10:30 if you're not aware. All right. Donna Drake. Max Juarez. Tracy Jacobs. Here. Brandon McClanahan. Here. Then Mr. Flores Laredo. Juan Flores Laredo is not set till 9:30, but are you here, Mr. Flores? Thank you, sir. All right, do we have any attorneys that are ready? Mr. Green?
Ready. It's Peace.
Lisa Ann Peace, CR 22-389. Ms. Peace, you'll come forward. All right, Mr. Green, I think Ms. Peace is set for docket call today.
That's correct, Judge. When we were here last, board had set it for docket call, and there was an issue with some videos from Camp PD that the ones that I had would not play. That day they didn't provide me with the videos. The state has also made a plea offer. I would just ask, and I visited with Ms. Curry prior to the case being called this morning, just ask that the court to allow us to have one more docket call so I can meet with this piece, lay out everything that I have and let her make the right decision about how to proceed the case.
Any objections from the state?
No, Your Honor.
All right, Ms. Peace, I'll give you one final docket call. Mr. Green, I've got December 12th and 14th.
Thank you. Either one of those, I think will work, judges. Let me make sure. We do the 12th?
Yes, sir. Ms. Peace, court sets you for final docket call on December 12th at 9 a.m. On that date, I'll expect to hear whether there's a plea agreement or there's going to be a request for some type of trial.
Judge, that's on my business, may I be excused?
Yes, thank you, Mr. Green. Good to see you. Mr. White, are you good?
Yes, sir, I am.
You ready, Mr. McClanahan?
Yes,
Brandon McClanahan, CR 23-109-110. Yeah, just. Thanks, judges. Right, these are calls numbers CR 23-109, CR 23-110.
yes,
State
sir.
versus Brandon Dwayne McClanahan for docket call. Go ahead, Mr. White.
Yes, sir, we're set for docket call. Ms. Curry and I have discussed this case. The state has extended us an offer yesterday. If I could have the 12 day, so I can bring Mr. McClanahan in and discuss with him the advantages and disadvantages of the offer. I think that's what I need. I don't think the state has any objection.
No objection.
All right, court will set Mr. McClanahan a final docket call. You said you wanted the December 12th date?
Yes, sir.
All right, Mr. McClanahan set for final docket call on December 12th. Mr. McClanahan, once you sign that, I want you to check in with the pretrial release before you go. You ready on it? CR 23-100. Believe this Jacobs is separate pretrial.
Yes, sir. Can we move this over to docket call?
All right, court finds already tested pretrial motions. Court sets Ms. Jacobs for docket call on December 12th at 9 a.m. And Ms. Jacobs, once you sign, I want you to check in with the pretrial release officer briefly.
Your Honor, that's all I have.
Do you have anything this afternoon, Mr. White? All right, I'll see if I can drum you up some business. Mr. Schmidt, are you ready?
Judge, I have Max Suarez for right. She's gonna make it on.
Yes, sir. What did you say the name was?
Max Suarez.
It's seven.
Okay.
Mr. Juarez, come on up. Mr. Juarez, just come on forward, come on forward, come on forward, and then hang it right. There you go. All right, this is cause number CR 23-185, CR 23-186, State versus Max Alexander Juarez for arraignment. Go ahead, Mr. Schmidt.
Your Honor, I've reviewed copies of the indictments. Mr. Juarez's name is spelled correctly. He understands the nature of each of the charges. We waived formal reading of the indictments, entered pleas of not guilty, and request pretrial be set December 12th if possible.
All right, court finds that Mr. Juarez has waived the formal requirements of arraignment. The court will enter his plea into the record, not guilty. The court then sets Mr. Juarez for pretrial hearing on December 12th at 9 a.m. Once he's signed and gets his notice of appearance, he's free to go.
Thank you, Your Honor.
Is that all you have, Mr. Schmidt?
Judge, I have a plea on Donna Drake.
You we ready on that?
We are, Your Honor.
Ms. Drake? All right, this is cause number CR 23-48, State of Texas versus Donna Corey Drake. Ms. Drake, if you'll raise your right hand, I'm gonna place you under oath. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you, Lord. Just make sure you speak up loudly and clearly for me.
Okay.
Your name is Donna Corey Drake, correct?
Yes.
And Ms. Drake, are you a United States citizen who reads, writes, and speaks English?
Yes.
Have you ever been diagnosed with any type of mental condition?
No.
In this case, you are represented by your attorney, Mr. Brian Schmidt. Are you pleased with Mr. Schmidt and his representation?
Yes.
You feel like you've had enough time to talk with him about your case, that you have all of your legal questions answered, and that you understand everything that you've read and signed in your plea agreement?
Yes, sir.
Mr. Schmidt, you believe Ms. Drake to be competent today,
Yes, Your Honor.
and you've explained to her the rights pertaining to this case and also the advantages and disadvantages of a deferred adjudication plea.
I have, Your Honor.
You believe that she understands all of her rights, her waivers thereof, and also that she is entering into this agreement intentionally, knowingly, and voluntarily.
Yes, Your Honor.
All right, Ms. Drake, you are charged by indictment with a second-degree felony offense of theft of property greater than $30,000, less than $150,000 from a not-for-profit. A second-degree felony offense does carry a range of punishment of not less than 2 years or more than 20 years confinement if you were to be convicted and sentenced, and also a possible fine not to exceed $10,000. It's important that you understand the inherent risk. I'm sure Mr. Schmidt, as he's already indicated, has already talked to me about the risk of a deferred adjudication. The court finds that the plea agreement in this case is that the state's recommending upon your plea of guilt that the court consider the evidence, not convict you, rather than defer a finding of guilt, place you on 5 years of community supervision, order restitution in the amount of $137,386.35 be paid today at the time of the plea, and that you have agreed to not apply for non-disclosure of your criminal records. In addition, you would have court costs and reimbursements. The court wants to admonish you that should the court accept this plea agreement and place you on deferred community supervision, it's important that you understand that a violation of any of the terms and conditions of community supervision that you've read over and signed today, a violation could result in the state filing a motion to adjudicate your guilt, which means to convict you. Upon hearing, if the state provides evidence or it proves that you have violated any of the terms and conditions of your community supervision, the court could conduct as a hearing. The court could do a multitude of things, including adjudicating your guilt, convicting you of that offense, revoking your community supervision, and assessing your punishment anywhere from the minimum 2 years all the way to the maximum 20 years confinement in prison. You understand those risks.
Yes, sir.
Understanding the plea agreement, understanding the risk, understanding the range of punishment, you still wish to go forward?
Yes, sir.
All right, Ms. Drake, then at this time, I'm going to ask you, how do you plead to theft of property greater than $30,000 or less than $150,000 from a nonprofit?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes.
Has anyone threatened, forced, or pressured you to plead guilty to that?
No, sir.
All right, the court does accept Ms. Drake's plea of guilt at this time. Mr. Schmidt, is there any objection to the stipulation of evidence in this case?
No objection, Your Honor.
Stipulation of evidence is admitted. The court takes judicial notice of Ms. Drake's judicial confession. Is there anything further from the state?
No, Your Honor.
Anything further from the defense?
No, Your Honor.
All right, the court's going to review the stipulation of evidence. All right, upon reviewing the stipulation of evidence, the court does find sufficient evidence to convict Ms. Drake of this offense. The court will follow the plea agreements as recommended by the state of Texas. The court hereby defers a finding of guilt on the charge of theft of property, $30,000 to $150,000 from a nonprofit, a second-degree felony. The court places Ms. Drake on 5 years community supervision. As a condition of that community supervision, orders her to pay today $137,386.35. And the court finds as a special condition to the community supervision, Ms. Drake has agreed not to apply for non-disclosure of her criminal records. The court assesses court costs in an amount of $290 and reimbursement fees of $85. Ms. Curry, is there anything else from the state?
Yes, Your Honor, I believe Mr. Smith's gonna make that payment now on the record so that we know it's made, and also, Judge, there is victim allocution on behalf of.
Okay, if you'll go ahead and bring the allocution, which is on, we'll go ahead. Thank you, Mr. Smith. All right, court's going to direct the court reporter not to record the testimony of the victim allocation. Go ahead, sir. With your step, and you can move that seat around if yourself.
Your Honor, thank you. My name is Justin Howe. I'm the lead pastor at Lakeside Baptist Church. I'd just like to read my statement.
Sir.
On behalf of Lakeside Baptist Church and myself as the lead pastor, we want to express love to you, Donna. It's been our sincere desire to act in a biblical, Christ-like manner towards you. Micah 6:8 has been our guiding verse in all of this. It says, mankind, he has told each of you what is good and what it is the Lord requires of you, to act justly, to love faithfulness, and to walk humbly with your God. You wronged God and our Lord Jesus Christ, as well as the people of the church, by your actions. For your sake, we are concerned that you may not yet have dealt fully with your sin honestly before God. We don't know. On our part, in our desire to honor God in all areas, we have been seeking to act with both mercy and justice for all involved. With the help of our government, and many thanks to our DA and our judge and our system here. We believe justice is being done, and we are thankful. But we also want to love mercy. We desire your reconciliation with God and our Lord Jesus Christ, and ours with you. Whether or not you have any interest in pursuing reconciliation with us, I want you to hear from us. We forgive you. I forgive you. We do not condemn you for your actions any further. We do not hold any ill will, nor do we desire pain and suffering for you. We hope that the justice being accomplished today will serve for your good in Christ and for the healing of your soul. We hope that through this process, you will come to trust God more deeply in everything. If you have not done so, we also hope that you'll come to the point of thoroughly confessing your sin and finding the forgiveness, the cleansing and restoration from God through faith in Jesus Christ. 1 John 1:9 encourages us with this. If we confess our sins, he is faithful and righteous to forgive our sins and to cleanse us from all unrighteousness. Today, you publicly admitted your guilt to a court, and we believe that is an important first step. However, we know, and I know that you know, that it is far more important to confess our sins before the one who can and will righteously forgive our sins by the blood of his son, Jesus. Again, we plead with you, if you have not done so already, humble yourself before God, confess your sins so that you may be forgiven and cleansed from the pollution of sin. Our earnest plea to you and to all in this courtroom is this: let's walk humbly with our God. And if God calls it wrong, we agree. If God calls something good, we agree. God will never be fooled by our self-justifications. And finally, may God be glorified in the outcome of these events. Thank you.
Thank you, Pastor.
Your Honor, record.
Thank you, Ms. Curry. Place that on the record. Description. Place on the record when visited. Curry has indicated that she has tendered the restitution check as ordered in this case to Pastor Powell of Lakeside Baptist Church. Ms. Drake, you hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they carry out the terms and conditions of the sentence. I'll have you step forward. You're gonna be fingerprinted with Deputy Martinez, and then you'll report to the probation officers. Come on up here. And they'll give you information on the next steps. Morning, Holly. We are going to, did you play baseball or softball growing up? Kid? Very, you ever see the difference between the fastball and curveball or a changeup? It's gonna be difficult for you then. We're gonna throw you a little bit of a curveball here and, ask that we take a different defendant than you were expecting. We have a Spanish speaker that's on our docket. And I'll give you all that information. We did not know needed interpretation, services. And so, it's gonna be, I think, a short hearing, so I don't think it's going to affect our scheduling this morning. So our other, Spanish speaker that I think we're helping on is going over his plea agreement, still, so we've got some time. So if you don't have any objections to that, then let me give you some information here. Okay, Ms. Abraham said that, she, emailed it to you. It's the 10:15. Gail Angel Castro Gavea, I believe. Excellent. So that's the one we're gonna take in. A little bit out of order, so I think we're gonna try to get them set up. Does the interpretation seem to be set up on your site correctly? Angle that microphone up towards the top. No, the stem, not the stem, just angle it up right there. That way.
Sí, sí estoy escuchando.
Okay, before I call the case, Ms. Field, I'm going to swear you in. If you'll raise your right hand, name and your license number. Ms. Field, you solemnly swear or affirm that you will make a true translation of the statements of the court, the questions of counsel, and the testimony to be given by the witness in the matter now on trial to the best of your skill and judgment, so help you God. Thank you, ma'am. All right, court calls cause number CR 23-166, State versus Miguel Angel Castro Gavea. Is that correct, Strawban?
I'm here for Naveed Alban. My name's Javier Balderrama, but Naveed's out in Denton this morning. But yes, sir, it is Miguel Angel Castro Gavea.
Okay. All right, and I believe that we are set for the pretrial this morning. Are there any contested pretrial motions?
No, not at this moment, Judge. We're just gonna request another pre-trial if possible. There's a lot of discovery. We're also looking into, uh, getting an expert out of Dallas for some of the discovery. So we're just gonna request that.
Have you received all of the discovery from the state?
I think so. I was gonna talk to, the state here in a little bit about, some questions that I have, but, I think for the most part, discovery is completed.
So when did you or Mr. Alban receive discovery from the state?
I think about a month ago, maybe. I'm not 100% sure, but I first saw the discovery about a month ago, about 3 to 4 weeks ago, so.
And so today you're requesting additional time to go through that discovery so you can determine whether or not any pretrial motions, contested pretrial motion be filed?
Yes, Judge.
Are there any issues with discovery that you need to address today as far as videos not working or?
No, I've gone through the discovery, videos pop up and work. There's a lot of reports, a lot of, black box info. So, yeah, I haven't seen any issues with discovery or being able to access discovery. So I think we're good in that regard.
Okay. Any objections to the state?
No, Your Honor, and I have had conversations with Mr. Alban. That is correct. They have the discovery. I think they've had it since October 16th. We've confirmed that everything is good on that. There is, the state does have a subpoena out for some more information. When we get that, we will pass it along to them, of course. But for now, they have all the discovery. We have no objection to another pretrial in this case, Judge. There is a lot of black box information to go through.
Thank you, Ms. Curry. Okay, board's going to grant the request for an additional pretrial hearing for Mr. Castro Govea. Board will set additional pretrial, you wait 30 days on sufficient.
That's more than enough, Judge.
The dates I have in December are December 12th and December 14th. One of those better than the other two.
And I'll look at my calendar real quick.
Yes, sir.
The 13th works out better, Judge.
Well, it's the 12th.
Oh, I'm sorry.
I saw what you tried to do there. Try to split the day.
The 12th, it does work great.
12th, yes, sir. All right, court sets Mr. Castro Govea for additional pretrial hearing on December 12th at, let's set that at 10 a.m. That will assist with having the interpretation services. Yes, sir. Set up. We'll call the regular docket at 9 a.m. So let's set that at 10 a.m.
Thanks, Judge.
And if I can see counsel real quick. All right, Mr. Valderrama, there is one additional issue the board needs to take up with regards to Mr. Castro. The court has been made aware that Mr. Castro has potentially violated one of the terms and conditions of his conditions of pretrial release. I'm not sure if you're aware, but Mr. Castro Gouveia, just like every other defendant in this court, must abide by certain conditions of pretrial release. The violation of those could and usually does result in the revocation of bail upon a violation. The information that the court's been provided by its pretrial release office is that Mr. Castro Gouveia tested positive for cocaine in October and also acknowledged that. So at this time, I'm going to ask Officer West of the Van Dyke County. So this is Officer Todd West with the Van Dyke County Community Supervision Corrections Department. Sir, if you'll raise your right hand and place your oath. Sir, do you swear that the testimony you give to the court today, the truth, the whole truth, and nothing but the truth, so help me God? I do. Okay, all right, now I'm gonna have a seat. I just want to get you. All right, Mr. West, can you inform the board with regards to Mr. Castro Gouveia's compliance with his conditions of pretrial supervision and or his non-compliance?
So on 10/21, Mr. Castro Cavea come to do a monthly report. And on that deal, I did a random urinalysis and 9:40 a.m. and he tested positive for cocaine.
Did you discuss the results of that test with Mr. Castro?
I did, and I asked him, I said, if you're clean, then it is what it is. If you're dirty, then, you know, and he said, well, I did. I used cocaine the Friday, I believe that was a Monday, or I'm not sure the exact day of the week without looking at the calendar, but he did admit to using the cocaine that Friday before he reported on 10/21.
Were there any other violations that you discovered that day?
No, sir.
Dave, do you have any questions, Officer West?
Briefly, Judge, officer, were all the usual protocols and security measures in place in collecting that sample and looking at the results of that sample?
Yes, ma'am.
That's all, Judge.
Mr. Walker, any questions of Officer West?
I got it.
All right, does Mr. Castro have any questions of counsel or the court that the interpreter can help us with at this time? Do you have any questions for counsel? And Mr. Balderrama, you speak Spanish, correct?
Yeah, I do.
Do you want to consult with your client to make sure there's no issue?
Yeah, just.
Balderrama?
No, Judge, we're okay.
All right, Then, Mr. West, you may step down. Thank you, sir.
Thank you.
All right, the court finds that Miguel Angel Castro Bebea has violated the terms and conditions of his pretrial release. The court therefore finds that his bail of $200,000 in this case is insufficient for the possession and use of the illegal substance of cocaine. The court hereby revokes his bail and sets new bail at $350,000 of cash and surety with the same conditions for pretrial release. Court is ordering the defendant to be taken into custody at this time. Deputy.
Stand up.
Do you have any other counsel that's ready on either case, Mr. Elliott? Thank you, Mr. Yes, sir. Thank you. Appreciate you being here. Mr. Elliott. I'm sure that you're ready on Bart Jones. Bart Jones, if you'll come forward, CR 23108. All right, Mr. Jones is set for pretrial today. Go ahead, Mr. Elliott.
We have no pretrial motions to be heard, and if we could move to a docket call, if it please the court, December the 15th, works for me, it works for the state.
You said 14th.
If that's okay, Your Honor.
All right, court finds there being no contested pretrial motions. Court sets Mr. Jones for docket call on December 14th at 9 a.m. Mr. Jones, I show that you're delinquent on your payments to pretrial release. I'm sorry.
Make a payment on it.
How much can you pay today? Okay, you're delinquent 120, so make as much as you can today and try to get that caught up before we come back to court, okay? All right. All right, and Mr. Jones is reset and I ordered you to go pay the $40 a day. Once it's signed, it's pretty good.
Your Honor, I have nothing else this morning. May I be excused?
Yes, thank you, Mr. Elliott.
Thank you, sir.
Good to see you. So Dave on Mr. Estrada. Mr. Estrada, are you ready?
I believe sign the paperwork, they have it ready. Judge, if I may, just set the sword real quick, she's having some medical issues.
Okay. All right, this is cause number CR 23143, State versus Tanya Selena Swart for docket call. Go ahead, Mr. May.
Judge, at this time, we have been unable to reach an agreement. My client would request one additional docket call. I have not had opportunity due to her medical situation to discuss final docket call, request additional docket call in this case.
Any objection from the state?
No objection, Your Honor.
All right, court will set an additional docket call from Ms. Swart on December 14th at 9 a.m. Ms. Swart, once you sign, I know that you're eager to get out, but I need you to report to pretrial release and sign your to pretrial release. Okay. She's trying to. Come right back over here, and they'll take care of you. Mr. Shaw, are you ready?
We are ready, Judge.
All right, Mr. Bill, I think we're about to get going on Mr. Flores. Just a minute. And Mr. Estrada, you can adjust that mic down if you need it a little bit lower. Excellent. So glad to hear that. All right, this is cause number CR 15-296, State versus Juan Daniel Flores Laredo. I believe that we're set complete today. The court, for the record, has already sworn in licensed court interpreter, Ms. Holly Hill, and Mr. Estrada. Is it my understanding that your client, Mr. Flores, wants to enter a plea to the court today to the following terms? That he would be pleading guilty to felony offense of accident involving injury with the recommendation of sentencing upon plea of guilty, punishment assessed at 31 days in county jail, credit for 1 day, fine of $3,000. As part of the plea, the fine will be paid today, and the defendant will be taken into custody today to complete the remaining jail sentence, for which he does not have credit. Is that correct?
For the remainder of the sentence, that's correct, Your Honor, but I believe the judgment reflects 32 days credit for 2 days is what I saw in the judgment.
Yeah, I see that. In the plea bargain area, it says 31 days credit for 1 day, meaning you would have 30 to serve. The other part of the judgment says 32 days with 2 days. The net's gonna be the same, but we do need to get those reconciled.
Yes, Your Honor, we'll get a.
So which one is it? Is it 32 and 2 or 31 and 1?
I believe it's 32 and 2, which is correct. That way we're not having to make any amendments to the judgment. And that would still remain as the same punishment. The fine still does not change, Your Honor. We're prepared to pay the fine today.
Okay, so Mr. Hartwell, if we can get the judgment changed in the plea bargain area to say 32 credit for 2.
Yes, sir.
Okay. All right, Mr. Flores, I'm gonna ask that you raise your right hand so I can place you under oath. Sir, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth? So help you God.
Gee.
All right, thank you, sir. You can vote here. Mr. Flores, are you a United States citizen?
No.
And Mr. Flores, it's obvious to the court that you do not speak English, but today you are being provided services through the Office of Court Administration Interpretation Services to enable you to receive information in your native language of Spanish. Do you agree with me on that? Mr. Flores, do you understand that if the court follows the plea agreement today, it could have negative consequences regarding your status within this country or potential deportation and issues regarding reentry?
See?
Mr. Estrada, I'm assuming that you've already talked about the potential immigration consequences that could befall your client if the court follows this agreement today. Is that correct?
That's correct. We have, Your Honor. We are in compliance with Padilla versus Kentucky, along with its progeny.
All right, thank you. Mr. Flores, you're represented by your attorney, Mr. Edward Estrada. Do you feel like you've had enough time to talk to Mr. Estrada about your case and that you understand everything that you agreed to and signed in the plea agreement? Do you have any questions of Mr. Estrada or the court before we go any further?
No, todo está bien.
Mr. Flores, have you ever been diagnosed with any type of mental condition?
No.
Mr. Estrada, do you believe Mr. Flores to be competent today? And if so, do you also believe that he's entering into this plea agreement potentially knowingly voluntarily?
I do believe Mr. Flores to be competent today, and at all times that I have represented him, he does understand the entry of a guilty plea, Your Honor. We have been able to discuss the facts of the case along with any possible defenses.
All right. And I don't have my code with me, so I'm gonna need state defense to refresh my memory. This is one of those hybrid felony type offenses that does allow for punishment in the county jail?
Yes, Your Honor.
It is, Your Honor. It's under the transportation code. These particular offense, it's not under the penal code.
Okay, thank you, Mr. Shaw. Thank you, Mr. Earl. All right, Mr. Flores, you are charged by indictment with a felony offense of accident involving injury. What is the range? What's the potential range of punishment?
Your Honor, the range of punishment is no more than 1 year in the county jail, but in addition to no more than 5 years in TDC. So it allows either county jail time or TDC punishment for the offense.
All right. And Mr. Flores, do you understand the full range of punishment in this case? And you understand the terms of the plea agreement? You understand that if the court follows this plea agreement today, that you will be convicted of this offense and you will be taken into custody today to serve an additional 30 days in the Banzai County Jail. You understand? And you are also prepared to pay your $3,000 fine today. All right, Mr. Flores, understanding the plea agreement, understanding the charge, the range of punishment. At this time, I would ask you, how do you plead to the felony offense of accident involving injury?
Pues no fue mi intención. Sí, culpable.
Okay, so you are pleading guilty to this offense, meaning that you are acknowledging that even though you didn't mean to, you committed a criminal offense, correct?
Sí, fue culpable.
All right, and Mr. Flores, has anyone threatened you, forced you, or pressured you to make this plea agreement, plead guilty today?
No.
You're doing this plea agreement today because that's what you want to do to resolve your case. It has been your decision.
Quiero estar bien y regresar con mi familia.
All right, the court will accept Mr. Flores' plea of guilt at this time. Mr. Estrada, is there any objections to the stipulation being admitted?
No objection, Your Honor.
All right, the stipulation of evidence is admitted, and the court takes judicial notice of Mr. Flores' judicial confession. Is there anything further from the state?
Nothing further, Your Honor.
Is there victim compliance in this matter?
Yes, Your Honor, we weren't unable we reached out, we weren't able to get a response, from the victim in that statement.
Thank you, Mr. Earl. Anything further from the defense, Mr. Estrada?
No, Your Honor.
All right, the court will review the stipulation of evidence. All right, the court, upon reviewing the evidence, finds that there is enough evidence to convict the defendant of this offense. The court will follow the plea agreement today on the recommendation of the state of Texas. The court hereby convicts Juan Daniel Flores Laredo of accident involving injury, felony offense. The court assesses punishment at 31 days confinement in county jail. Excuse me, the court assesses punishment at 32 days confinement in county jail. The court will give Mr. Flores credit for 2 days of time already served. The court will order that Mr. Flores serve a remaining sentence of 30 days in Banzai County Jail. Court orders him to pay a fine of $3,000. As part of the plea agreement, court orders the fine to be paid today, time of plea. Court also assesses court costs of $290 and reimbursement fees of $40. Mr. Flores, you are hereby remanded to the custody of the Banzai County Sheriff so he can carry out terms and conditions of the sentence. I'm going to have you just a moment come forward to be fingerprinted with Deputy Martinez here in front of the court. Do you have any questions before we conclude the case?
No.
All right, Mr. Flores, you'll come forward to be fingerprinted.
And Judge, will he be allowed to go to the district clerk's office to pay the fine before he's remanded?
Typically, no. Typically, no. Can he tender the money to you and you pay?
He
for
can,
it?
yeah, that was what I was gonna suggest.
Yeah.
I could go make the payment.
Yes, we'll take him into custody and we'll let you take that money and go across the. I think I gave you, missing the key part of the test passed. Of appeal. Maybe it's like my judgment. Stipulations. Brady.
We don't have calculators, that's what it is. It's a shuttle.
It's not going
Yeah,
down.
we got stipulation.
Got Brady, you got certificate of appeal, you got stipulation, you got judgment. Okay, that's one.
Yeah.
State ramp. Is that all in this? We had those two, right? Well, I mean, we had two and we added, right?
We had one, and we added,
We had one and we added, so Miss Bill's done. All right,
and she doesn't get her.
okay.
We did it.
So Miss Bill, did you get the state ramp? Yes, ma'am, that is correct. Yes, ma'am, thank you so much for being here. Really do appreciate your help. Bye-bye. We missed that on both. All right, Mr. Manning, here you ready?
Judge, I have Mr. Sean Davis.
All right, this is cause number CR 23-95, State versus Sean Ray Davis, pretrial. Go ahead, Mr. Manning.
Yes, Judge, we were, as you see on the docket, waiting for cell phone analysis. I spoke to Mr. Keltner, or sorry, Deputy Keltner on November 7th. And he has made progress, but is requesting additional time. My understanding from what his request was a setting in the late spring. I don't know if the state is aware or agrees with that, but that's the timeline he gave me.
Late spring of 2024.
Your Honor, I can shed a little bit more light. He asked for a setting in the second half of the first quarter of next year. The reason.
Isn't that another way of saying late spring? The second half of the first quarter.
The reason being, he found some material that indicates that he needs to do a deeper analysis. He did give me some numbers for how many items there are. It's well in excess of 100,000 files that he's going to have to analyze in addition to his duties as patrol lieutenant and several other cell phone analyses that he is currently running. I believe if we could get a setting in maybe towards the end of February, or if Your Honor would rather set something in between, just in case we're able to get something quicker. But yeah, he is asking for it as long as the court will grant.
And Judge, I would just request, once the state completes their analysis, I still need the opportunity to sit down, review that discovery with my client, prepare defenses. So we would request that later spring reset.
Let's set a status hearing in January. I don't want to set this thing out 3 to 4 months without some kind of status. So let's set, Jermaine, how does January 18th?
Judge, I believe I may be in trial in Kaufman County that week. Is there possibly a date after January?
It'll cost more money for you if I do that.
It's always
prepared to pay today.
Judge, if it looks like I have, that was the 18th.
Yeah, let me see what my, let's see what the criminal dates look like in January. So my criminal dates for the 16th, the 18th. We could set it on the evidentiary date, which would be like the 30th.
Judge, that'd be fine.
Do that. Let's do that, because that won't take up much time on that docket. All right, court sets, Mr. Davis for, status on cell phone analysis for January 30th. And then maybe then we'll know kind of where, Dick Keltner is. And then we can kind of estimate from there how much longer on the next set.
Yes, Your Honor.
Are you ready on next?
Judge, also ready on Mr. Dakota Dole.
Mr. Dolphin. This is cause number CR 23-147 and 2021-539, pretrial and motion to adjudicate, I believe, on the misdemeanor. Go ahead, Mr. Mann.
Judge, we have requested discovery multiple times in this case. I know that the DA's office has had several roadblocks getting that discovery. And my understanding was that it was on the portal. Earlier this week, I met with my client and it was not on the portal, so I've been in touch with the DA's office. They have copied some, but not all of that. And so we're still waiting the finalized discovery on that, so I can go over and compare it for this case.
And Your Honor, there is one disc that is ready for pickup today. There is another that, or more material that is simply too large for any of our discs. So Ms. Melton has had to order a larger external device in order to copy over the rest of the information that's been requested.
And that's just on CR 23-147, right?
That is correct, Judge.
Do
you know about how much time you think will be necessary?
Your Honor, I would expect that we would have the rest of that discovery copied over probably sometime next week. And probably be able to have that to Mr. Manning by the end of next week would be my best guess.
Judge, at this point, I have approximately 10 discs to review on that case. So it's gonna take a little bit of time on that plan as well.
We don't set it in December, unless we push it to February.
And Your Honor, as far as the rest of the discovery that is available, all the documents.
And we have reviewed those at my office with my client, so we are just waiting on the videos.
You do February 1st or February 15th?
Judge, February 1st will work.
All right, court sets Mr. Dole for pretrial, the CR 23 case, February 1st, carries the motion to adjudicate same day. Both cases at 9 AM. And once he signs his notice, it's free to go. Who's next?
Judge, I have two more, and then I have some additional resets. I got Mr. Bobby Evans.
Bobby Lynn Evans, CR 22-271. All right, Mr. Evans is set on his motion to revoke today.
That is correct, Judge. This is my first time, our first opportunity to meet Mr. Evans. I request a reset so we can discuss the allegations in his motion to revoke and set him out for consideration.
Don't have a contested issue docket in December, on set November 30th. That's.
Judge, that should work.
Work. All right, court sets Mr. Evans on November 30th. Mr. Evans, did you pay the $500 in your attorney fees to the pretrial for the probation line?
Not able to get it done for today, but I do have it today to pay.
Yeah. Okay. So when you leave here, I'm just gonna order you to go over to the probation department and pay that.
Okay.
Go ahead, Mr. Mayor, I'm sorry.
Judge, I just didn't know if you want to take up Mr. Gilson's case now.
Sure, let's go ahead and do that, get it out of the way. Cause number CR 23-181, State versus Francis Patrick Gilson or Raymond. As I said before, the board has confirmed that Mr. Gilson is in custody in the Hunt County Detention Center. Court's going to reset Mr. Gilson. We'll just set that for Raymond status on custody for December 14th.
Thank you, Judge. Will that be at 1:30?
Yes, sir, let's go ahead. We'll set that at 1:30, anticipating that. Well, I'll tell you what, let's just set it at 9. And if he's in custody, then we'll just bump it over that day. In case he's released.
That's just.
Yes. I'm trying to see. Hang on, Mr. Mayor. Let's see what he's for. Yeah, it looks like he's in custody on a motion to revoke assault of being a council member with previous conviction felony. Bail is $40,000, so. Yeah, let's just go ahead and look at that at 1:30. Can we do that? I mean, it really doesn't matter.
I've crossed out 1:30, but not in, so we'll just
Leave it. We'll leave it.
take care of it.
He's in custody, we'll do both the custody topics. Mr. Adams, are you ready or? Who you ready on first?
Doesn't matter which one you're on.
Leon Thomas Baker, CR 21350. All right, Mr. Baker, set for doctor call today.
Yes, Your Honor, Mr. Baker and I, another meeting together to, go over his case, one more time, and, I want to have, take another attempt at having some substantive, plea negotiations with the Robbie. So I'm asked, at this point, I'm asking the court to set us for another docket call.
Are there any objections to the state?
I'm sorry, Your Honor, I just want to make sure, I've got the correct name. This is Mr. Baker?
Yes, sir.
Okay, no objection, Your Honor.
Problem I have though is I think I said today is the final docket call. This is his third setting for docket calls. Is there any reason he can't make a decision today?
Your Honor, Baker lives in Fort Worth, which is about a 2.5 hour drive from my office. And, we've had difficulty, meeting and to remove the discovery in this case. We're gonna resolve that by having a Zoom meeting over the weekend.
We'll be back on the 28th. Have a pretty large document on it. Okay, so I'll be a part of it.
I am trying
have a docket call in Smith County, not only, Your Honor.
All right, I'm gonna go against my policy here and not setting after the final docket call, so I'm gonna give you one more, Mr. Baker, but on December 12th or 14th, whichever one y'all pick, there will be no more extensions after that date. We'll have to make a decision. So which day do you want? 12th or 14th?
Will have to be the 14th, Your Honor.
All right, Mr. Baker, you're set for another final docket call on December 14th at 9 AM. And I believe pretrial release said that they want to see you after you sign your notice. Mr. McLeod here. Come on up, Mr. McLeod. This call number CR 22-334, State versus John Hughes McLeod Jr. for docket call. Go ahead, Mr. Evans.
Good morning, Your Honor, on behalf of Mr. McLeod. I've asked a forensic expert to review the CAC video for us. I've seen it. I'm asking for someone for an impartial set of eyes to look at it. She's made one attempt to do that. However, when she went to the district attorney's office, there were some technical malfunctions and she wasn't able to look at the video while she was there. This was in October last month, and that has not yet been rescheduled. In addition to that, now this particular expert is not terribly expensive. However, there are two others that I think I'm going to need in order to effectively represent Mr. McLeod in this case. And my largesse can only extend so far. To that end, I'm going to have to file an AQ motion with the court for the court's consideration. And to do that, I'm going to need to get Mr. McLeod's affidavit of indigency together as an attachment for that motion. Mr. McLeod has a template for that affidavit, so he's going to start working on that for us. We can have that motion filed within the week. I'm still waiting to hear back. One of the contemplated experts is Dr. Proctor. I'm waiting to hear back from him just to confirm if he can do it. The other one that I had in mind was sane expert. I already visited with her, and so that's ready. As far as what I need to do to make my part day request, that's in the can. I'm just waiting to hear back from Dr. Proctor so I can provide that for the court's consideration all at the same time.
December 14th.
Okay, yes, Your Honor.
All right, court sets Mr. McLeod for additional docket call on December 14th, 9 AM.
Thank you, Your Honor. We'll have those. I'll get those motions filed for the court's consideration as soon as I can.
Yes, sir. I'll be looking for them. Ross, are you ready on Mr. Johnson?
Yes, Your Honor.
Come on up. Terry Lorenzo Johnson, CR 23-184. All right. Oh, Johnson. All right, Mr. Johnson has been charged by indictment with the offense of theft of cattle, horse, or exotic livestock less than $150,000, a third degree felony. Mr. Cos, have you had an opportunity to review the indictment with your client? If so, are y'all ready for arraignment?
Yes, Your Honor, we're willing to waive arraignment.
Is his name spelled correctly?
Yes, Judge.
And, he understands what he's charged with and he understands the range of punishment.
That is correct, Judge.
And, he wants the court to enter his plea of.
Not guilty, Your Honor.
All right, court finds that Mr. Johnson has waived the formal requirements of arraignment, understands what he's charged with, his name is spelled correctly, and court enters his plea of not guilty into the record. Mr. Cost, the court will set a pretrial hearing, usually try to set those about 30 days or so. Out, the 2 days I'm looking at, December 12th and 14th.
The 14th, I've got another trial in Dallas, but I believe the 12th is going to be. Oh, yes, the 12th is available.
Both is better. Okay, so the court's going to set Mr. Johnson for pretrial hearing on December 12th. That'll be at 9 AM in this courtroom. And of course, as the Code of Criminal Procedure requires, any contestant pretrial motions that need to be taken up need to be filed 7 days prior to that date, served on the state.
Very good, Judge.
If there are none, Mr. Cost, then what the court does is there are no contested pretrial motions, then my next setting will be the docket call. That would be enough time, 30 to 45 days for you, Johnson, to review all the evidence, negotiate with the state, decide if there's going to be some kind of plea agreement. If not, then we come back on docket call or agreement, when we set it for trial.
Sounds good to me, Judge. Thank
All
you.
right, thank you, Mr. Cost.
Excuse?
Yes, sir.
Thank you, Judge.
Ms. Nix. All right, this is State versus Victoria and Nix, the cause numbers CR 12-175, CR 12-176. Ms. Nix, if you'll raise your right hand and place your finger, ma'am, do you swear that the testimony you give in court today will be the truth, the whole truth, and nothing but the truth, so help you God? Yes, sir. All right, well, again, Ms. Nix, you're currently on probation, correct? Yes, sir. And today you're before the court, asking the court to grant you an extension period of 1 year. It looks like you were set to expire in February of 2024. And you're asking for the court to extend for an additional 1 year, extending you out to February 23rd, 2025. What's the reason that we need to extend you?
Money, I'm trying to pay the back fees and stuff. I went to safety and I'm just trying to get caught up. And, I have, I believe 90 hours left of community service, and that's it.
Do you believe, Ms. Nix, that the court grants you the extension that will enable you to have a better chance of being successful on probation?
Yes, sir.
You said that you went to safety.
Yes, sir.
When did you go to safety?
I was there last year.
Last year.
I've only been out like 6 months.
Okay. And how are you doing?
I'm doing actually really good.
What would you say about safety? Your honest opinion.
You have to have the mindset to get anything out of it, to be honest. I mean, you have to want to, you get what you give in, so.
Yeah, I think that's fair. I think that's a good way to do that. Do you feel like you got something out of it?
Yes, sir.
So I'm assuming you went down there with a mindset of getting something out of it.
Yes, sir.
Can you tell me one thing that you learned down there that you've actually applied to your life in the last 6 months?
To stay focused and not worry about everything else that's going on around me, and be selfish for once in my life and look at me.
Good. Okay. And Ms. Nix, you're wanting to extend this so that you have a chance to succeed, not because anybody forced you, pressured you, told you to extend the probation. All right, board finds that Ms. Nix has agreed to the extension of her community supervision. Board, as part of that, is also going to waive your probation fees. The board is going to waive your analysis fees for that extended period. In cause number CR 12-176 and cause number CR 12-175, you will have to pay probation fees, your analysis fees. So we're gonna waive it on one case. That way you're not having to both of them. Thank you. All right, Ms. Nix, glad to see that you're doing well. You look well. So I've signed this extension. Let's get this finished. Let's get this finished, get you done, and get you back to your life, okay?
Sir.
All right, come over here and see Ms. Burns, get this signed, and there you go. Jimmy Lynch. All right, good morning, Mr. Lynch. This is cause number CR 23-187. Mr. Lynch, it appears that you've been charged by indictment with the second degree felony offense of assault of the peace officer. Court has admonished you that the range of punishment for this type of offense, if convicted and sentenced, has a range of punishment of not less than 2 years or more than 20 years of prison, and also carries a potential fine not to exceed $10,000. The court understands that you have requested a court-appointed attorney. Court has reviewed your paperwork, and the court finds that at this time you do not meet the financial qualifications for a court-appointed attorney, meaning that you have, under the eyes of the law, you have sufficient assets or resources available to hire an attorney. So what I could do, Mr. Lynch, is I can reset you and give you time to try to hire an attorney. Okay. I'm going to. I'm gonna set you on December 14th, okay, so that's a little over 30 days, let's see. It's 5 weeks, okay, so what I expect you to do in 5 weeks is I expect you to go and start contacting attorneys, tell them what, and just take, let me see that, form here. Let me put the charge on here so that he can take this with me. So the attorneys are gonna ask what you're charged with when they're trying to determine what the charge. All right, Mr. Lynch, you're gonna sign here in this clearance form, and you can take that information and use that whenever you speak with the attorneys. And so, just like every other service that's available, okay, some attorneys charge more, some charge less. You're not gonna know unless you make the calls. All right, so the first one you call, is an amount that you just know you can't afford. Don't just assume that that's gonna be the same for all attorneys. Some offer payment plans, some take credit cards, some don't, I don't know. So you're just gonna get on the phone and do the work. So I expect you to come back with an attorney. If you don't come back with an attorney, I expect to see the work that you've done in trying to get an attorney. Okay? You have any questions? All right, we'll see you back on December 14th. All right, so Mr. Manning. All right, Mr. Sanders is still on his way. He may be arriving any moment. On Mr. Snelson. All right, of course, going to stand in recess, give Mr. Manning an opportunity to speak with his clients and for Mr. Sanders to arrive. All right, we are back on record. Mr. Manning, who are you ready on?
Judge, ready on Mr. Alfonso Perez Junior.
All right, Mr. Perez, I need you to show up to court at the time that we start for, 9 a.m. Okay, so I wrote on my docket, issue a warrant for Mr. Perez if he's not here on time. Okay, so make sure you're here on time. All right, separate docket call, go ahead.
Judge, we've reached an agreement on Mr. Perez's case. We have executed a waiver of jury trial. And we request that be set out a little bit. The reason we executed the waiver of jury trial is Mr. Perez has got a lot going on with his family right now. And so we just asked for a little bit of time for him to get stuff squared away so he can start off probation right foot.
Okay, we have that waiver.
Yes, Judge. May I approach?
Yes, please. For the record, this is also CR 23-7 versus Alfonso Perez Junior. Mr. Perez, sir, if you'll raise your right hand, I'm placing on the oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? Okay, well, your name is Alfonso Perez Junior, correct? And Mr. Perez, I have a document in my hand that appears to have your signature entitled Waiver of Jury Trial. Did you read over this document and discuss it with your attorney, Mr. Manning? Yes, sir. Do you understand that you do have the right to a jury trial in this matter in which you can cross-examine the state's witnesses, confront them, confront all of the evidence they have against you, but you also have the right to waive that jury trial and proceed with a plea or a bench trial on your case. You understand that? Yes, sir. You understand, Mr. Perez, that once you waive your right to a jury trial, if the court finds that you've done that intentionally, knowingly, voluntarily, because that's what you wanted to do, then that right may not be restored to you later, meaning you don't get to waive it today. And then as you get closer to trial or however plea agreement, and you change your mind and you say, now I want my right to jury by trial restored. Once you waive it, it's going to be waived. You understand that? Yes, sir. Okay. And has anybody threatened, force, or pressured you to waive your right to a jury trial? No, sir. Okay. All right. And the court finds that Mr. Perez understands his right to a jury trial, that he has intentionally, knowingly, and voluntarily waived the same, that he has been joined by his counsel, who Mr. Manning, who has also informed Mr. Perez regarding his legal rights. The court finds that the state has also waived its right to a jury trial. The court will approve the waiver of jury trial and allow Mr. Perez to resolve this case by plea agreement. See, Mr. Perez is charged with what, evading a real.
That's correct, Judge. And just to put on the record as well, the plea agreement that we've reached is for 3 years deferred probation.
Okay, so we just need to set that for a plea, is that correct?
Yes, Judge. And as I asked, if we could set that out a little bit further, just so he can start off probation on my foot.
All right, so you're thinking January or February or what?
Judge, I believe January should be fine.
Because the latest I've got this year is 14.
Judge, his father's not doing well health wise, and so if we could set it a little bit further than December 14th.
See, would you said you're gone on the 18th, correct?
Yes, Judge. Trial. If that trial goes away, I could. If you want to set it for the 18th, I could attempt to let the court know closer to that trial date.
I may have criminal dockets on January 2nd and 4th, but just whatever reason my calendar is not showing to be available.
Judge, I would be available on the 4th if that's what the court would like to do.
4th. All right, I think we do have a criminal docket that day, so. All right, court will set Mr. Perez in for plea before the court January 4th at 9 a.m. And Mr. Perez, once you sign your notice of appearance, I want you to come and check in with the pretrial release department. Okay? Yes, sir. Who's next, Mr. Mann?
Judge, next I have Mr. Bobby Evans.
Bobby Jean, I'm sorry. Bobby Evans,
Bobby Lynn Evans.
sorry, I was looking at Bobby Shaw. We've already done Mr. Evans.
I'm sorry, that's correct.
You're
Judge.
thinking of Shaw.
I'm thinking Shaw.
Bobby Jean Shaw. PR 23-11E for pre-trial. Good, Mr. Mann.
Judge, if you recall, we had reset this pretrial, in anticipation, the state had said they were gonna file additional charges at the last grand jury. We have, at this time, not received notice that he's been charged with anything else. We have no contested pretrial issues on this particular case, so I guess we'll go ahead and move it forward to Doc Paul.
All right, court will set Mr. Shaw for docket call on December 14th at 9 AM. And Mr. Shaw, once you sign your notice of appearance, I want you to also check in for trial release.
Okay. Judge, also, just for the record, I do not have in my files, a order of appointment for this particular case. I was appointed on his previous cases, but I went back and double checked before court today. I do not have an order of appointment for CR 23-118. If we just get that squared away, I don't mind handling Mr. Shaw's business. Just want to make sure we have it on the record.
Yeah, let me make sure that we got one. Should be. All right, Mr. Taylor, thank you. And I see the issue, Mr. Manning, on that, because it looks like that appointment says arson and evading arrest.
Yes, Judge.
Doesn't say.
And that, I think, was added. He was arrested after I was appointed on those original two.
All right, Miss Abraham may needs to do a new appointment. She's probably gonna come in. Mr. Abraham, the bottom of that says arson and assault. Is that the assault that's being referenced here? That was this class A assault. This one's a second degree.
This
is evading.
evading arrest.
That's a evading. Oh yeah, evading arrest and arson. So we're trying to find the appointment for assault. Impeding breath or circulation.
I believe that was an added charge, so I may not have got that. So
We
I'm
just-
gonna go up
We'll
and
just do a new appointment and add that on there. Who's next, Mr. Mason?
Judge. Let's do. If I'm gonna make an announcement on Mr. Hare, I was informed by Mr. Sanders' office yesterday that he has retained Mr. Sanders. I have no opposition to that, and so I don't oppose. He did reach out to contact. I just wasn't able to get it signed off and filed.
Okay, all right, I'll call him up just.
Next, I have Mr. Ryan Higgins.
Ryan Matthew Higgins, CR 23-128, CR 23-129, pre-trial.
Judge, at this time, we have no contested pretrial issues. We received an offer for his case and discussed that, and we has to be reset on the docket call announcement.
All right, court sets Mr. Higgins for docket call December 14th. 9 AM. And Mr. Higgins, I show that you're delinquent on pretrial release fees. So I want you to report your pretrial release today and make a payment. Next, Mr.
Mr. John Henry Johnson,
Mr. Johnson. It's cause number CR 23-163, State versus John Henry Johnson, pretrial, go ahead, Mr.
Judge, we have no contested pretrial issues at this time. We have received an offer yesterday, I believe. I've discussed that with my client. We request to be set for docket call announcement.
All right, court sets Mr. Johnson for docket call December 14th, 9 a.m. Once he signs, it's free to go. Who's next?
Kristen Lopez,
Ms. Lopez. Cause number CR 23-57. State versus Kristen Nicole Ramirez Lopez for pretrial, go ahead.
Judge, no contested pretrial issues at this time. We received an offer and I expect we'll be making a counter offer based on my conversation today. Request to be set on the docket call.
All right, court sets Ms. Lopez for docket call December 14th. She signs and gets her copy, she's free to go.
Judge, ready on Mr. Lowe,
Mr. Lowe?
may we approach?
Yes, sir. All right, this is in cause number CR 23-59. State versus Jeremy Ray Lowe. Right, court finds that that the state has filed a motion to dismiss Mr. Lowe's case. Court hereby grants the state's motion to dismiss. Mr. Lowe, you're free to go. If you want a copy of this, we'll get you a copy.
Judge, ready on Miss Malco, Ginger Malco.
Ginger Lorraine Malco, CR 23-60. Malco set for pretrial.
Yes, Judge. We are waiting on the co-defendant's case in this issue. I believe they're still on pretrial. We request that track to the co-defendant's case for this, as I think that'll be dispositive on Miss Malco's case.
But there are no pretrial issues.
No contested pretrials at this time.
All right, court will set Ms. Malco for docket call December 14th. 9 a.m. Next signs is free to go. Who's next, Mr. Mayor?
Judge, Mr. Tyler Tadlock.
Mr. Tadlock. Cause number CR 23-76, F 190, 191, 192, 193. Say versus Tyler, Jason Tadlock. So we're set for arraignment and all of 190 through 193. Y'all call on 76. Go ahead.
Yes, Judge, we were withhold announcement on 76, on 190 through 193. His name is spelled correctly. He understands the charge against him as well as the range of punishment. Pleads not guilty at this time. The request to be set on the pre-trial docket.
All right, court finds that Mr. Tadlock has waived the formal requirements of arraignment. Cause number CR 23, 190, 191, 192, 193. The court will enter his plea of not guilty into the record, sets each one of those matters for pre-trial hearing. Is December 14th sufficient, or do you need more time?
Judge, because in the early cases and the discovery I anticipate is going, I have not received all the discovery at this point. I request a little bit further on.
What about that January
Fourth
day, Mr. Tadlock for pre-trial and docket call on CR 2376. January 4th. All right. Mr. Tadlock, I need you to report to pre-trial release so you can sign your conditions on the pre-trial release. Have you already done that? No, okay. Come on over there and they'll go over the paperwork with you, okay? Mr. Tadlock will exit, he'll exit out the back and he'll meet you in the hallway. Okay, that's just. Who's next?
Judge, I believe, I've got Mr. Chenault in my last case.
Mr. Chenault. This is cause number CR 23-8, state versus Joshua Lee Chenault. That's set for docket call today. Are we entering a plea today?
Judge, it was my understanding that we were going to be entering a plea today. However, after speaking to my client, he wishes to reject the state's offer of 10 years deferred probation, and seeks to go forward with this to trial.
Okay. And you explained to Mr. Chenault the court's policy on not accepting plea agreements after docket call.
Judge, I've explained that to him previously. Prior to this final docket call, I did not discuss that with him today. However, I'm sure the court would make him aware of the court's policy.
Mr. Chenault, if the court places you on the jury trial docket, as is your right, okay, the court's not going to allow you to enter a plea agreement after today. So if you go to trial in 6 months or a year, you decide right before trial that you want to accept the plea offer that was made, whether the state offers it or revokes it, I don't know, I don't control that. But the court will not allow you, the state, to enter into a plea agreement after today. So you're sure at this point that you determined that you want to go forward with a trial on this case? Sure. Okay. All right, the court will set Mr. Chenault for jury selection beginning December 4th. So Mr. Chenault, on December 4th, you will appear here at the courthouse. You will not go to trial on that day, okay? You'll show up, you'll meet my staff, and they will give you the reset date. And you'll continue to do that until your case is tried. Mr. Manning's not gonna be required to appear on the 4th or any other day with you until he's notified that your case is in the top 10 cases, could be selected for trial. So show up on December 4th at 8:30 down on the second floor, and the court staff will be there to greet you. And I'm sure the pretrial release officer will probably be there as well. If he's not there, you have to make sure that you're complying with the conditions of pretrial release.
And Judge, we're gonna ask that Mr. Chenault be broadcast as well.
Okay, all right, and so go ahead and sign your notice of appearance, and then come over here and have a seat. We're gonna do a UA test.
Judge, with the exception of Mr. Chenault, I believe that we've done business this morning. May I be excused?
That's everyone, Mr. Mayor. All right. Yes, sir. Thank you. You may be seated. Appreciate it. Mr. Sanders, are you ready? Yes. Who would you like to proceed on? Mr. Snelson, if you'll come forward. All right, this is cause number CR 23-119 and CR 23-120. Mr. Snelson is set for a call. Go ahead, Mr. Sanders.
Judge, with his case, I was gonna ask if we could set this for a plea in a couple of weeks. I met yesterday with Miss Curry, and I think we've got agreement worked out on the case. I'm just gonna ask if we could set a plea, maybe that last week of November.
Are you here already that week? I mean,
No.
Okay. Tell you what, let's set it for pretty full on the 28th. We'll set it on evidentiary day.
Okay.
So that'll be November 30th.
Okay.
And is that a probation plea, or a time plea?
Yeah, probation.
Probation. All right, so we'll set that at 9 a.m. on the 30th. And Mr. Sanders, I'm gonna need Mr. Snelson to report to pre-trial release this morning. My records indicate that he's not reported in September or October. That's what my records say. So anyway, check in with them this morning. Mr. Hare. It's cause number CR 23-154, State versus Charles right here. Mr. Hare is set pre-trial, so understanding. Mr. Sanders, that you have been retained on this case and you're asking to substitute. I may have already signed that, I'm not sure. If you've submitted.
I don't think so, because actually I thought I was gonna grab Mr. Manning. I thought he was gonna still be around to get him to sign off, but I'll just email that to him. Or I may have already emailed it and just haven't gotten it back from him yet.
Well, that's okay. I mean, he's already said on the record that he's fine with that. So if you want to, just send me an order substituting.
Okay.
That way we'll have that of record.
Okay.
We're set for pre-trial. I'm not sure if you're ready for pre-trial.
No, Your Honor, I asked if we could reset it. I've got to get the discovery. If there are any pre-trial issues,
December 12th or 14th.
Say December 12th probably work fine.
We could make it sooner, or I could do it on that 30th. That just doesn't, you're coming back, it just doesn't give you, it only gives you 3 weeks.
Right.
Rather have the 14th.
Probably December, probably the 12th would be better. I know the 14th is already pretty busy, so the 12th would be great.
All right, court sets Mr. Hare for pre-trial on case number 12. Court grants the withdrawal of Mr. Manning and orders the substitution of Mr. Sanders as retained counsel for Mr. Hare. And I show that Mr. Hare is delinquent $180 on his pre-trial release. So I want Mr. Hare to come over and visit with pre-trial release before this. Mr. Hare, can you make a payment today towards your delinquency?
I think tomorrow, Friday.
How much can you pay? How much can you pay tomorrow?
I pay all of it.
Pay all of it tomorrow? Okay, I'll order you to pay $180 tomorrow to pre-trial release. They're gonna close at noon tomorrow.
No, we're closed.
Oh, sorry, they're closed tomorrow. So Monday. All right, so I need that paid by Monday, okay? Sure. All right, you're free to go. All you have, Mr. Sanders?
That's all I have, Judge.
All right, did they treat you well in Drake County this morning? And we are on YouTube.
That's right. They did. It was great. A great experience
great.
over there. Yes.
Were you in Judge Charles's court at all, or?
No, just Judge Conzac just had a couple misdemeanor revocations, and one I would have been over here sooner, but one of them on his revocation, all of his time was in Smith County Jail with the hold from Gray County, and I wanted to stick around to make sure they got the credit like it needed to be so that he would be released to that.
Absolutely, yeah.
So it all worked out all right. Just took
Sure, he wanted you to be there as well, so.
And I don't know.
All right, I believe that concludes, I think everyone showed. So we didn't have any nice things, so that's good. All right, so that's going to conclude the court's morning criminal docket. Court will resume at 1:30. Court's afternoon docket. Stand, recess.